Good afternoon. Thank you for coming to our meeting tonight, February 8th. At this time, if you would stand for the Pledge of Allegiance. I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please stand for 10 seconds and remember our previous mayor, our friend R.V. Johnson. He has had some minor surgeries going on, so just always prayer for R.V., such a good friend to the city of Indian Rocks Beach. And also to Rini DiNicola, who was married to our old mayor, Bob DiNicola. She fell and she's also in rehab at this time. Thank you. You may be seated. Dean, would you please call the roll?
Commissioner Hopper.
Here.
Vice Mayor McCall.
Here.
Commissioner Hanna.
Here.
Commissioner Hoopnickel.
Here.
Mayor Kennedy.
Here. Thank you, Deanna. With that, we'll ask for presentations from our Sheriff's Department. I always like to tell everyone that the Sheriff comes in about 15 minutes before the meeting, so if anyone would like to personally speak to the Sheriff there in the back, or you have a conversation with them. With that, how are you today?
Good afternoon. My name is Deputy Bauman. This is Corporal Harris. I placed the reports up on your desk there.
Okay.
We did have 2 assaults. If you look on page 2, we did have 2 domestic arrests. If you go over to page 2, also on the larcenies on page 1, that's our CVS, people helping themselves to the alcohol. So, but everything is down compared to last month. We had 15 arrests this past month. You can look through the list through them. We had 4 DUIs, 2 domestics, a couple of disorderly conducts, misuse of 911, and possession of controlled substances. On page 3, you can see our total stats. We had 890 events in the city. We had 122 units respond, or 1,222 unit responses. And you can see the traffic stops all the way down to the house checks. The one area that I want you to take a look at is transport to Safe Harbor. If you're not familiar, the Sheriff does have our own homeless center, so we took 6 homeless people to Safe Harbor so they would have a place in shelter away from Indian Rocks on the streets. You can also see that we got 4 DUIs. Best news, I got to be careful how I say this, there was no accidents in the city of Indian Rocks for the month of January. And you can see 312 citations to include parking citations and even a boat citation. Also, we did extra patrol on the beach for the dogs on the beach, and we seem to have pretty much cleared out the 8th Avenue situation with the dogs down there. Plus the weather currently is kind of helping us with that. So we'll keep on that, keep the patrol up.
Thank you for doing that. I know I reached out because we have been having a problem with dogs on the beach. And sometimes residents don't like to, I don't want them to really get involved either because it's kind of a heated discussion. So I appreciate it if you would continue to do that.
Yes, ma'am.
Is there anyone here who has any questions tonight for the Sheriff? Any questions on any of the reports?
Thank you, Tom.
Anyone? Okay. Thank you.
Have a great evening.
You too. Thanks for coming in. Our fire department has a meeting at present, but normally our fire chief, Jeff Davidson, will be here to give us a report. He may show up later, but if not, I know the report is online. And we will go to public comment. We have a 3-minute time limit for every speaker, and any member of the audience may come forward and give their name and address and state any comment or concern they may have about any matter that comes which the City Commission has control, excluding agenda items. All statements made to the City Commission shall be made to the City Commission as a whole, not directed to an individual City Commission member, and no personal or slanderous remarks shall be permitted. No speaker shall be interrupted, and no debate shall take place between the speaker and the City Commission. And so at this time, if it's not already on our agenda tonight, if there's anyone who would like to come up and give us your name and your address, you have 3 minutes to speak tonight.
Hi, my name name's Kelly Farrington. I live at 541 20th Avenue. I just finished construction on that home, and so we just got our CO, and then right after that received impact fees. So I have a big issue with the impact fees, and I just wanted to gain some clarification about that and give you my point of view why I think that they're unfair. So addressing the 3 impact fees, one of them is a development impact fee. So strictly for building a bigger home, and improving my property value, I'm fine for that. I'm already paying more in property taxes by that, building a bigger home there, so I think it's kind of a double whammy for, again, doing nothing but trying to stay in the city and improve the property value. 2, the second one is the recreation impact fee. So presumably because you build a bigger home, you're putting more of a stress on the parks and recreation, which I think is an unfair presumption. I moved from 410 Harbor Drive South, so I've lived in the city for 17 years. The same 4 people that were there are the same 4 people that are at the current 20th Avenue house. So we're not stressing the city in any way by increasing traffic to the parks, beaches, or using any more of the recreation that we paid taxes for already. And then also the same goes towards the mobility fee. So from my understanding, the mobility impact fee goes to the presumption that because you built a bigger home, that you're impacting negatively the transportation system and the road wear and tear. Again, my same argument is that I literally moved 1 finger over, and so my property taxes already, or my taxes already go to that, and I'm not negatively impacting the city any further with that. My larger frustration with those fees, however, lies in the fact that if anybody is impacting the city negatively in recreation and mobility, it's the Airbnbs that seem to be unaddressed. So there are times when I lived over in Harbor Drive South, some of these homes have 20 cars in front of their houses on a nightly basis. So that's negatively impacting mobility, transportation, road wear and tear. Also with the use of the parks, we've seen them down there and they don't treat our park system very well. They kind of, there's abusive wear and tear, I guess, on the swings, the benches and things like that. And also, being at the beaches, the trash that's being left behind, the amount of traffic that's down there. So in my opinion, for someone that loves the city and chose to not move out, like the majority of our neighbors are doing because of these Airbnbs, I chose to stay here and I want to improve the city and I love the city and I want to stay here. But at the same time, I feel that these fees are addressed to the wrong people. So I think that if you want to try and do something both about the Airbnbs and address these issues, I would find them, put these fees onto them. So every Airbnb has to pay these impact fees on a yearly basis, instead of having the residents that want to stay here and improve the city, develop that type of fee. So,
Kelly, during my comments, and I'm going to ask the city manager if he has anything that he wants to add as far as any of that, we'll address that. But thank you for your comments on that.
thank you.
All right, thank you. Is there anyone else who would like to come up at this time who has questions or comments that don't have anything to do with any of our agenda items? Okay, hearing none, we'll close the public hearing, and I'm going to go to the report of our city attorney, Randy Mora.
Thank you, Madam Mayor. Briefly, legislative session has begun. The bills are filed. We're tracking the progress of these individual bills, and I'm checking them right now because I hadn't checked since last week. I can tell you that House Bill 6003, which would have repealed the preemption altogether, has had 0 traction. The Senate Bill 512 and its corollary House Bill 325, which would preempt all local regulation of online vacation rental platforms, but would allow local governments to require their registration. That one has already gone through one of its committees. Passed through. Actually, sorry, forgive me. It passed through the Regulated Industries Committee on January 11th. Then it passed through the Community Affairs on a 6-3 vote on February 2nd. So as recently as last week, on February 4th, it was pending reference review under certain rules and being referenced to the Rules Committee. but it's moving through the legislature quite quickly. So our ability to regulate or that of local governments is likely to be restricted further. It does involve a 30-day cure period for vacation rental owners who fail to register with local governments, and mandates that any fines or failure to register must be refunded if the owner becomes compliant within that 30 days of receiving the notice. So again, the aim of most code enforcement being compliance. It's targeted towards, did you get compliance? Are they registered? They are, move on. And not seeking to enhance local regulation of that. There are a series of other bills I've told you in our last meetings about bills 280 and 620 that would require potential exposure for business damages, whether those be net or gross, profits or income. And then the other bill that would require specific findings for any legislative enactments and what those impacts might be on businesses, and also changing the standard of review that legislation is subjected to, when local legislation is subjected to, when submitted to a legal challenge in the courts. And both of those come with potential attorney fees as against the local governments who are defending claims brought against them. I can tell you, as our firm has been involved with and is very engaged with the Florida League of Cities and the Florida Municipal Insurance Trust, we are tracking those closely. In some instances, we've been asked to assist with proposed, or at least look at proposed amendments. There's a lot of dialogue going on between the members and the various special interests on how these various issues will be navigated. Preemption is a foremost issue in this, as it has been every other session for roughly the last 5 to 6 years. I don't see that changing soon. It certainly is a concern as this body looks to how to best respond to its constituency and regulate going forward. Beyond legislative session, I'm working with your city manager on a series of ordinances and resolutions, continuing to bring you into compliance with the current state of the law and making sure your code remains updated and revisited as appropriate. Other than that, I don't have anything else to add, but I'm happy to answer any questions you may have for me.
Does anyone have any questions for Randy tonight? We sent a letter on 520, is that correct?
Well, the way it was written, it was at 620 and 280. It was written to address both of those that was drafted. I believe that went out through city administration, so that is gone.
So would there be anything you would change in those letters? Because I guess what now, I'm going to call them all. I'll call the ones that at least are in Pinellas County to let them know. I mean, is there anything that needs to be changed? Because I'll use the letter as a reference.
I don't know that there's anything in the letter that necessarily needs to be changed. The legislation evolves. It's hard to have any correspondence match. You'll have to forgive me, Mayor, because you know I'm ever the cynic. I don't know that the letter necessarily changes the balance of power against special interest
But I mean, at least if I
dollars.
call them.
Yeah.
It's better to call them than to get a letter, because who knows if they even read them.
And that was going to be my point. I don't know if the correspondence resonates, but elected officials like yourselves are responsive to their constituencies. As we've seen with short-term rentals, manatees, and other issues in this community, when you guys start getting phone calls, you start saying, maybe I should think about this differently. You start getting phone calls and emails and really realizing, okay, this is important to my constituent space. If that's something that organically this community desires to raise, from an informed standpoint as to what the issues are, and not just like, you love short-term rentals and I hate you. There may be a response to that. I don't know. I can't speak for elected officials. There's a very good reason why I choose not to be one. I respect the hell out of what you folks do, but I sit in this lane and just try to make sure that if we're going to make policy, we make good policy, and as you folks do it, we do it within the confines of the law.
Anyone have any questions for Randy? Dan, will you print me another of that copy of the letter that we put out, so I have it in front of me when I'm calling you? I appreciate that. Thank you. With that, we'll go to our city manager, Greg Mims.
Good afternoon. I was going to say good evening. A little earlier. I have a list, so it'll take me a little time. You received the financial report in the packet. I'll be happy to answer. There's nothing really to note there. The budgets are tracking like they should. The recreation budget is where we charge out event. And in the fall, we did most of our events. That's why that was sitting at 51% already, because we kind of picked out the bigger events. But finances are good. Code enforcement, there were, by our staff, this does not include the sheriff's office, there were 55 parking citations issued, 3 notice of violations letters issued, and in 2004, Gulf Boulevard, per the resolution that the commission passed, the dilapidated garage was torn down 2 or 3 weeks ago. The owner will be billed for all of our expenses involved in that. If that's not paid within a reasonable amount of time, you will see a future agenda item to lien the property. So there'll be a lien on the property, so if the property changes hands, we'll get our money, but hopefully the owner will play. So that property now is in compliance with the dilapidated part of the code that we have. Other updates, go through capital projects that are in the budget. The new backstop fencing for the baseball field will be installed beginning in July, so that field will be shut down for about a month while that's going on. The restriping and repainting of the tennis courts over at Maryland Park to accommodate more tennis, pickleball courts. That'll be done the week starting after Easter, after our seasonal folks start to leave. Bay Boulevard reconstruction project, which is Bay Boulevard from 18th to 22nd. All the curb work's done. We made 2 or 3 drainage improvements on that street. It'll be milled and paved beginning next week. That'll take about a week, so we'll be finished with that. The Brown Park basketball court is in the budget. It'll be completely reconstructed. A PO has been issued to the contractor. We're just waiting to work out the dates on that. One project that will be done at the time we repave Bay Boulevard is a section of beach trail between 23rd and 24th. There was a large multi-unit condo building that was built, and during the course of that construction, they damaged beach trail that we had paved about 4 years ago, really from one end to the other. So before we closed that project out, we gave the contractor the option of milling and paving it, or give us the money and we'll mill and pave it. So they paid us $8,500, and when we mill and pave Bay Boulevard, you'll see that section of beach trail milled and paved. POs have been issued for the code, the new Polaris for the Code Enforcement Division. PO has been issued for the replacement public works truck. PO has been issued for the replacement solid waste packer truck or garbage truck. And y'all know what the market's like. We're at the mercy of, we think we'll get those maybe like July, August. We'll be waiting for a while. And also the budget was $15,000 to replace the antiquated telephone system that we have in City Hall. There was a lot of effort, a lot of good folks in City Hall to research options, and we involved people like Matt, our computer expert IT person in that process. And long story short, I've signed the purchase order to enter into an agreement with Spectrum to go with the Spectrum phone system. It's the high-tech VoIP phone system, all new fiber optic lines. It's set up in such a way that if we have a storm, and I don't like to mention storms, if we have one of those, that we literally can pick up the telephones and plug them in at remote locations and they automatically work. So instead of spending $15,000 to put in something that we buy, we're going to spend $900, and it's a 3-year agreement. We can renew it, continue it. It's automatically built in where we get free upgrades through the system. So what I would ask, and my plan is, unless there's an objection by the commission, is we have a real need. When the budget was adopted, we allocated, I recommended y'all approve, we allocated additional funds to try to scan and automate all our old records. Now that we don't have a building department, and the building department is a huge generation of paper, we want to get all that automated. We've added some additional money in the clerk's budget for that to expedite that. What I'd like to try to do is balance that $15,000 less than $900 is to allocate that money to try to get the rest of it done. For example, we have a microfiche machine back by Dean's office, that we have these boxes and boxes of little fish, and people on occasion will want to come in and look at those, so they have to pull the fish, put it in the machine, and to be honest with you, we can't even get replacement parts for that machine. If it were to break, we're just kind of out of business. So part of what we do with that money is we would, the same firm that scans all our documents, we'd scan all those fish, and then those would be available online for the public to pull up their own information. So unless there's an objection by the commission, the savings on the phone system, that's what I intend to do with this, is to expedite getting all that done. So unless y'all start shaking no, maybe that's where we're headed. A couple things, we're pursuing additional funding. I had a call this week for additional funding to complete the Gut Boulevard undergrounding project. It's through the governor's office. I'm just sending them a summary of what we think we need and kind of the project boundaries. You know, we've entered into, we have an engineering firm working on phase 2, which would take us from the 5th Street intersection north. We hope, we think, don't hold me to it, we think that that money will get us to somewhere around the county park. So I'm going to give the governor's office a number of about $8 million to see through some of these state and federal funds if we can get the remaining amount of money to finish it, to actually complete Gut Boulevard. Because if we don't try to get the outside money, when we finish phase 2, it literally could be another 8 or 10 years unless some other money appears. So I just want to make you aware that I'm putting in a request for that. It's no match funds, which if we can get it would be 100%, which is good. And also, through one of the local businesses in the business district, there was a discussion with the governor when he was here recently about the possibility of any state funds dealing with additional parking facilities or a structure in the business district. And I've gone individually and talked to you about that. So that was brought up on the conference call. There seemed to be at least some positive feedback about at least the possibility of the city asking for money for a project like that. I need to have a follow-up conversation with some of the state people about that, but most likely where this is going to head is on the parking garage or whatever this might turn into. That's going to require me at some point in the very near future to ask for a special work session where I can come in and we can publicly talk about the pros and cons of going with that idea, and what all may or may not be involved. So I know I've talked to y'all individually, but publicly I want to tell you that we're having discussions about that. And it's not that I'm recommending building, for example, a 2 or 3 story parking garage in the business district, but it's some resources, some funding that may be out there, and some policy makers for the city. You know, I would bring that forward to you, weigh out what we believe are the pros and cons of pursuing it, and then y'all will give me direction on how you want to handle that. Because obviously I don't want to spend 6 months pursuing something and there's not policy group, which is the commission, y'all say like, we don't want to do that, to do this, or we want to do something different. So the good news is there's some funding opportunities and we're pursuing that. Another thing that we're working on is we have a need to update the city sign ordinance that we have. And I don't want to throw people into panic when I say that, because by update, I don't mean change the size allowance for anything. In other words, nothing's taller, nothing's bigger. There's just been a good bit of court cases, litigation, particularly all the way to the federal courts over people's freedom of speech and their rights to put out signage. And really, the bulk of this amendment is definitions and clarifications of what people's rights are about signage, and in particular, like on residential properties. And I don't know, Randy, you want to say anything about that while I'm on that for something?
Yeah, thank you, Greg. Around 2015, the Supreme Court of the United States issued an opinion, I believe the case is Reed versus Gilbert, and the case concerned signage, but it had to do with, you know, its impact was much broader than I think the issue that was properly before the court. And what the courts decided is that temporary sign regulation must be content neutral with limited exception. And what that means is you couldn't have an ordinance that says political signs can be out this long, signs for garage sales this long, and a Komen for the Cure 5K this long. Those are all temporary signs with no direct commercial purpose, and so they should be regulated similarly. The largest challenge in harmonizing that has tended to be how you harmonize that relative to political campaigns, because political campaigns tend to be when we see the most proliferation of temporary signage in a community. And it's easy to say, well, we don't want 55 signs for a real estate open house or the Girl Scouts selling cookies, but the moment we have an election with a slate of national, state, and local candidates, and you start limiting the number of signs somebody can have, how do we do that in a way that meets the needs of candidates and politically interested members of the public alike, while still preserving the public health, safety, welfare, and aesthetics of your community. That's not the only way. I will tell you, it is when we have, and our firm has seen a few communities in this county and otherwise adopt these. When we've seen them, that's been where some of the challenges are. We are about 6 or 7 years removed from it, but there's been, even as it passed, a lot of communities held off for a year or two to see what are the courts saying about its application and the ways communities have adapted. So we have a little more guidance now than the templates that have been circulated in the past, but it's still in the law. 5 to 7 years is like a brand newborn. It isn't tested exhaustively, but we have some inklings and impressions of what is appropriate, and that's what we're looking to draft. And so, and you know, of course, the reason you don't just take one from one community and do it to the next is each community is a little different. In some communities, they have what they consider to be proprietary signs with their, you know, wayfaring and logos, and you know, some cities are very commercial that way, so they've had to be very careful about, okay, we want to get our intellectual property lined up before we start lining those things up. And, you know, there's all kinds of challenges and unique legal issues, but that's what we were working with your manager on. Commissioner Hoofnagel may be relieved to know that it'll happen after his tenure, so the number of whereas clauses may not bristle you as much as it might him. But you know, this is something that is sort of top down. When the courts start telling us what to do, we try to make sure our findings and our formats are in alignment to make sure that we have defensible and show that this is an informed and not a shoot from the hip amendment. So that's kind of where we stand.
I just have a couple of things. So the way that process will work is we're working with the draft that I've had for several months. Just working with Petty and Mike Kelly particularly about it. We'll make our updates to it. It'll be run through the city attorney's office one more time, and then the process will be, it'll be sent to P&Z, and P&Z will spend probably more than one meeting going through it and talking about it, and then ultimately it'll come to the commission, because you know, P&Z is just a recommending body, so is the Board of Adjustment. So that's where it is, and Ed, you'll be happy to know that I've struck about half of the whereas without the document. Just a couple of things real quick. We, back in 2020, installed solar panels on the City Hall complex. And the museum's doing really well. We're hitting about 80% of the power down at the museum. For City Hall, we're not hitting that high. We're in the 60% range now, which for this building with old air conditioning units is good. But one of the things that I've realized is that, just like my memory is getting shorter and shorter, is that I had a lady that approached me particularly about 2 weeks ago out front, and she was talking about the solar lights on the beach and all the good things that we're trying to do. And she said, you know, have you ever thought about solar panels on City Hall? And I said, well, as a matter of fact, we have. And the reason why people don't think about it is that all our solar panels are on the warehouse back here in the back, so visually, they don't see it. So what you're going to see out front is, I've asked Dean and Lauren, we're going to put like a little mini solar panel out front with a little educational thing under it, just to remind people that we're utilizing solar power, because we're still one of the first cities, particularly in the smaller cities in the state, I mean in the county, to do that. This is a little educational thing. We recently received notice that the city received a certificate of achievement in excellence. It's in finance reporting again, something that we've earned now for numerous years in a row, so I'm going to mention that. Ed are off the hook. I really need to ask y'all to wrap up the charter officer evaluations. Those are things that are required with my employment agreement and with DM, so I'll work on that. And the last thing I'll just cover briefly was the topic that was brought up earlier about impact fees. And I don't necessarily have an argument with anything that the speaker previously said about impact fees, but the impact fee ordinance that we had has been in place for, I don't know, a long time. When I got here, to be frank with you, it was not implemented equally across the board. It was not consistently applied. One of the things that I did through looking at how we operate and how we deal with the public and how we treat people is that the impact fee ordinances are worded the way they're worded, and it's very clear when you impose those. So the way they're being applied to people when they make improvements to property is based on the adopted ordinance. So the speaker that talked earlier, although I agree with maybe some of her concerns, is that it's been implemented the way the ordinance is. So at a future date, if the commission would like for us to set aside a work session and we can talk through the three different impact fees that the commission adopted per ordinance and set the rules per ordinance, we can do that. But there's no waiver provision in there for waivers. We've literally assessed hundreds of people since I've been here for eight and a half years for these same fees. So that's kind of where that is. So it's been applied the way it should be, but at a future date, if y'all want to discuss it and adjust it or amend it, that's the decision of the commission, but it's been applied the way it's written. And one last thing, and I'm not an attorney, not your city attorney. You have a good one up there, and I don't play one on TV. But I can tell you, you've been involved in the vacation rental saga. That if you ever attempted to do an ordinance to do some special stick towards vacation rentals and impact fees, that's probably where you're going to get yourself into some legal issues, because that's the very reason why, unfortunately, the legislature continues to try to chip away at cities' rights to regulate vacation rentals, because I think a lot of it was exaggeration that people would go to complain to the legislature about such and such city adopted these very stringent retaliatory kind of ordinances towards vacation rentals, and the result is we have what we have. So that's why when we worked on the vacation rental ordinance for y'all for months, there was discussions about, well, can the business tax receipt or the business license fee be $1,000? Well, yeah, you can do that, but it's probably not going to last long, because they're gonna. So you have to be careful with all that. But I'll work at the direction of the majority at some future date. Y'all want to put that on an agenda, have a discussion about it. But I can just tell you, carte blanche, it's being applied the way it's written.
I think that's a good idea. Is everyone, are we all in agreement that we'll bring that before the commission? Thank you, Greg. Greg, do you have anything else tonight?
No, I think I've talked too much. So.
Okay. Commissioner Hufnagel, do you have any reports?
I do. February 26th, the Beach Art Center is having a Western-themed fundraising gala. There are limited tickets still available, so if you're interested, please search on their website or contact the folks at the Art Center. It's their main fundraiser for the year. So, sign ordinance, just quickly. There were some comments about the whereas clauses. My concern with the whereas clauses was that the number of them confused the reader to the point where when you actually got to the logic of the sign ordinance, you were numb to what it was saying. And in the draft, they were approving 25-foot pole signs. So please make sure when you're going through your sign ordinance, don't let there be animated signs, inflated flappers, and all those kinds of really annoying signs, which should not pollute our aesthetic environment in the city. We're a small town, we don't need to have a big neon board up there. And at the same time, think about how to accommodate the needs of our small businesses for things like sandwich boards and other temporary signs which are up to help promote their business survival. So those are really the two themes I would hope that the body would be able to work on later. I won't be here for that, but support our small businesses and make sure we don't have animated flapper type ridiculous signs that distort the view. We danced a whole lot around this concept, but I just wanted to emphasize to the speaker that brought up a point. The city government can do whatever the charter lets it do, unless the state tells us we can't do it. And the state has told us we cannot regulate short-term rentals. That's been taken away from city authority. It's something called preemption. You may hear people talk about it, but when the state did that several years ago, it severely limited this legislative body's ability to do anything to single out and try to control short-term rentals. It doesn't mean we like them. It doesn't mean we think they're great for the city. It means that we as a legal body are powerless to do anything about it. And we've been spending a lot of our lobbying time trying to go back to Tallahassee and explain how that really hamstrings us as a governmental body. But to be honest, the lobbyists have overtaken Tallahassee and they've made it sort of cemented. And every year, Tallahassee meets and they try to make more and more inroads to further restricting not only the grandfathered preemptions, but every aspect of short-term rentals they're trying to eliminate control over at the local level. And that's it's a threat to our town. It has been, it's resulted in significant change in the character of our city, and it's something we'll be fighting for the remainder of the time that we do stay here. Thank you.
Thank you. Well said, Commissioner Hufnagel. Commissioner McCall, Vice Mayor.
Just a real brief announcement. The Homeowners Association started back with their Mix and Mingle. They held their first one in January, Krabby Bills, of course, well attended. It's good to see everybody in the community back out. A lot of new faces, which we have, here in the city. So, met a lot of new folks. And the next one is going to be actually a combination of one of our newest businesses and one of our oldest. It will be held at Anecdote Brewery on February 17th. And actually, Pajano's is going to partner up and supply the chow.
Nice.
So, come out on the 17th, enjoy yourself, meet our new neighbors, meet our old neighbors. It's nice to be back out and about, we'll say. That's all I got.
Thank you. Commissioner Hanna?
Not a whole lot. Kelly, I appreciate your points. I wholeheartedly agree with having a meeting to revisit some of those. First thing that comes to mind, of course, this is outside of what we'll discuss, but first thing that comes to mind is when you move, you have portability for some of your taxation to go to the new house. Possibly that might be some guideline as to, okay, how much impact is this family of four doing at the new house? So, just a thought, it did not fall on deaf ears, so thank you for that. And Ed, I'm going to miss the whereases, that's all I can say. That's all I have.
And in social news, the Cocoa Crush is looking to open up at the end of May, first week in June.
Yes.
Wow.
That's good. I wanted to say that the Winterfest is February 19th, Saturday, starting at 10 a.m. at Calvary Episcopal. It's an event that's been going on for many years, and I know that Father John wanted everyone to know and remind them to come. They have a dog contest, and they have booths. So if you're around on February 19th, it's a nice day to get out. Just to address some of the comments that were made, Kelly, as far as powerless, I don't know if we're powerless per se, because my dad said to fight the battle whether you win or lose, and we have been doing that. So if for some reason there's anyone out there that thinks that we're not fighting it, I know the commission has talked to our representatives. As a resident, you need to call our representatives, specifically Representative DeSiglia. Right now, it is moving through the Senate. I would call all the senators. I'm going to call them all. We have sent letters to all of them, all of their committees. They put me in a rickety 2 years ago plane that I thought I was going to die in, and went up there and I saw all of them, and we stopped at that point what we were. I don't know if it had to do with all of us who went up there to fight it. I didn't even want to go because I didn't think we had a chance in any way, and we did. We were able to stop any more of what was going on. I give everybody my phone number. I am not afraid for anybody to have my phone number. I have a big German Shepherd and nobody come near me. And I will tell you all that right now, you have a problem in any way, whether it's short-term rentals or anything, and if you got a pencil, it's 727, it'll be on this, 560-7565. You call me. 3 weeks ago, Jean Scott, who was a commissioner, called me up and put the phone up, and she said, "Do you hear this?" And they had the microphone out there, and there was a big bachelor party, and I called Greg, and we called the sheriff, and they went down there, and the guy was fine because we have a process that we go through, and we don't like them. I mean, we have short-term rentals in this community where we have designations. Zoning designations where they were allowed that we put in many, many years ago. We don't want them in the residential communities. Commissioner Hofnagel has told everybody that they have taken over our area, and we cannot do anything about occupancy, duration, or frequency. Those are the three main pieces that the legislators prohibit us from doing.
Duration and frequency.
Duration frequency. So, but that being said.
Well, what about occupancy then? Because some of these, sorry, am I allowed to talk? No. sorry.
You want to just mention the occupancy piece for a second?
I don't want to, but you're my boss, I'll have to do so.
Yes.
The question has been raised as to occupancy. Occupancy, as we have talked about this as a body collectively and individually in the past, regulating occupancy. It presents a series of challenges. The first being uniform application and enforcement, and also just taking people. How do you prove that case when you go to court and say, before a magistrate or a judge or otherwise, they had an X number of people in violation? Well, they weren't occupying. We were here for a football game, or they were just dropping off the nephew. And I mean, the number of excuses that will come is one thing. The other part of that is what the landscape looks like for that regulation and the groundwork you've made for it, because we've seen communities who have imposed occupancy restrictions and then been subjected to legal challenges, the blueprints of which I will not put forth at this point. We've talked about them exhaustively, but subjected to millions of dollars of exposure and liability, and fighting off at least 24 cases at a time in the court system, all based on occupancy restrictions. And while insurance policies and plans can be put in place fiscally, that takes time, that takes cost, and we've talked about whether that cost was worth the potential exposure, especially with the potential diminishing return in terms of enforcement. What we've started to see is a landscape from the legislature that states you can regulate some aspects of short-term rentals, but any regulation you impose on them must be uniform throughout your community. And so do you want to start turning away relatives and the like and saying there's too many people sleeping here overnight, while we're all here for my mother's funeral? Well, some people are going to need to find accommodations quickly. I don't suggest to you that it is impossible. It presented legal hurdles and obstacles that we were not willing to countenance in those previous discussions, but it has been carefully considered. I don't speak to those things in the abstract when I reference that litigation. My law firm successfully defended against them based on very specific legal documentation that is not available to us in this particular context. The challenge with occupation is until the emergence of these platforms around 2008 and thereafter, occupancy was not a statistic that was tracked. It wasn't, you didn't build a home and report to a city, this is exactly how many occupants I'm going to build it for, and the city say, okay, you are approved to have 12 overnight occupants. And so if you're going to say historically this property has had X amount of occupancy, how do you track that? How do you establish that? When that wasn't a significant data point until the last roughly 10 to 15 years. And so those are some of the challenges presented by that issue. So it has been considered, and again, we'll work at your pleasure.
And that being said, we have put restrictions, and we have, you know, if you know that there's someone that's doing that and they don't have the proper identification, all you do is call the city and we'll be out there immediately. They have to have they have a number, they have to have some specific title so that everybody knows that that's a vacation rental. Anything that has to do with parking, garbage, if they violate that, you know, those are the kinds of things that we can regulate, noise. And if you or anyone you don't want to call, then you call me. I have no problem with it whatsoever. So,
can I speak to two things on that, Mayor? One, to the extent that there's a perception that the city doesn't enforce, that it has these rules but they're not enforced. My firm just had a trial last week in the local ordinance violation court for somebody who had thus far not yet paid their registration fee to simply operate, much less whether they were operating in alignment with all of the other regulations. The other side of that I want to make sure people understand is, I recognize that I don't live in this community, I don't live on the fingers, but I am very sensitive to the changes that have happened in your community. I'm very sensitive, and not just this community. You take the short-term rental bill, the home-based business bill, Burt-Harris Act amendments, and all these things, and we are slowly seeing an erosion of what we would call community. And that's not just happening here. That happens at the state and people we elect and how those things operate. But we also have to recognize that we are a community, a state, built on tourism and economic engines, and the economic engine that is tourism that fuels the quality of life that we all enjoy. And it is very difficult, whether here in Tallahassee, balancing those competing interests. If you own your property and you say, well, listen, I'm willing to live in half my house and I can use this to make revenue because I'm part of the great retirement, resignation, renegotiation, termination, whatever name you want to give it. People are finding new innovative ways to make money because you have to. And so I wouldn't say that this, I don't wish for the unified, or stretch that. City's position as a city has not been, we are against short-term rentals. We are for harmonizing the interests of our residents and visitors. And that's not always an easy thing to do. And I think you have a tremendous advocate and leader in your mayor, and she has sat here and offered you to contact her, as you well should. She is your representative. The one thing I want to caution you about is there has been a change in the law relative to code enforcement, and one of those changes is whereas you used to be able to make anonymous code enforcement complaints, barring very specific legal showings, you cannot do that anymore. And so if you make your voice heard to the mayor, and she in turn tells you, well, you're going to need to take this to the manager, she is not avoiding helping you. She's not being some mealy-mouthed politician who's kicking the can. She's subjected to her own statutory limitations. Again, this is a new thing. For 30 years, we just did it the way it made sense. And now you can't do that. And in part because of the impact it was having on that particular industry, that was a change that was made. And so, Greg, I know you wanted to add to that. I don't know if that's what you wish to address, but there are systems in place to facilitate proper legal code enforcement complaints. Greg?
No, I think I'm good.
Thank you.
okay, anything else on this subject? Okay, hearing, we will move again to additions and deletions. We don't have any that I'm aware of. Is there anything that anyone? Okay, we'll move on to the consent agenda. And do we have a motion? And Randy needs to read it first, excuse me.
No problem. Madam Mayor, there are 4 items on the consent agenda. Item A is the approval of the December 14, 2021 regular City Commission meeting minutes. Item B is approval of the January 11, 2022 regular City Commission meeting minutes. Item C is resolution number 22-01, a resolution of the City Commission of the City of Indian Rocks Beach, Florida, announcing the results of the March 15, 2022 municipal general election, providing for the re-election of Mayor and Commissioner Joanne Cookie Mawson Kennedy, election of Commissioner Drew Bond, re-election of Joseph D. McCall, each to be seated for 2-year terms, and providing for an effective date for the commencement of their respective elected terms. This has been a reading of resolution number 2022-01 by title only. And item D, renewing an agreement with Trask Daniel LLP for city attorney services for an additional 3 years, and increases in the monthly retainer, hourly services outside of the retainer, and paralegal services rates. These are items A through D on the consent agenda, Madam Mayor.
Thank you, Mr. Morrow. Do we have a motion?
Motion to approve the consent agenda?
And is there a second?
I'll second it.
All in favor?
Aye.
Motion carries. Thank you. We'll move on now to public hearings. Our first public hearing, 6A, is BOA case number 2021-01, which is 1701 Gulf Boulevard. Randy, could you please read?
Yes, and before I begin with the reading of item 6A, the 3 items on the public hearing agenda are each quasi-judicial matters. For the benefit of those present and the Commission, as a reminder, in a quasi-judicial posture, you are not making the law, but rather applying the established law to the facts, testimony, and evidence presented to you this evening. You will consider the competent, substantial evidence, weigh it, and make a determination as to the appropriate relief to be granted or denied, as it were. Before we begin, the first case is Board of Adjustment case number 2022-01, considering a variance request from section 110-241 of the Code of Ordinances to allow for 3 15-foot diameter cantilever umbrellas and 3 12-inch by 12-inch permanent in-ground concrete umbrella bases in the front yard setback for the property located at 1701 Gulf Boulevard, Indian Rocks Beach, Florida, and legally described as Indian Beach Revised Block 65, lots 3 and 4, parcel number 01-30-14-42030-0650030. With that said, for the property located at 1701 Gulf Boulevard on application 6A, has any member of this body had any ex parte communications with the applicant or their agent in advance of these proceedings?
No.
All having responded in the negative, has any member of this body conducted a site visit for the limited purpose of evaluating the application before you this evening? That is to say, did you visit it to evaluate that, and are you generally aware by your existence in this community?
No.
Okay, all having
So
responded in the
that
negative?
means, we go there for dinner, and we see the floor, and I didn't know it was coming before us.
Okay. The fact that you've dined at the establishment is not that.
That's
Did you
right.
go there looking at the contours of this
No.
proposal
No.
and then sit there, make notes,
Okay.
make any determinations?
I think, it's one of our great restaurants in our community. A lot of us go there to dinner, so I want to make that known.
Okay. So with that in mind, will the staff and any person who intends to offer any testimony, including the applicant, their agent, or any member of the community who plans to speak on this application for 1701 Gulf Boulevard, please stand and raise your right hand. If you're here to talk about, which remind me of the restaurant again, I have another city in Guppies, I was going to say that's someone else. Guppies, so stand and raise your right hand. Do you swear or affirm the testimony you are going to give this evening is the truth, the whole truth, and nothing but the truth? Thank you. You may be seated. The way this will work for those men here, because we have a couple of hearings, the procedure is generally, I do that fun little show you just saw. A member of the staff, Hetty Harmon, will usually introduce and present. If the commission has questions of her, they will ask them. Then the applicant or their agent will come forward. You will have an opportunity to make your presentation. After that, if the commission has questions of you, you may do so. After that, it will be open for public comment. Then staff will make closing comments and questions, and then the applicant will have the final word. They will close the public hearing, at which time the public participation part is over, and this commission deliberates and renders its decision. The decision of this body, unlike the Board of Adjustment and Advisory, this is a binding decision, not the advisory decision. The decision issued this evening. So with that, Hetty, if you could please proceed with staff presentation.
All right. As you know, it's 1701 Gulf Boulevard. And there's a closer in view of the site where we're looking at over the front area, where now you can see there's umbrellas there. And this was the plan because they did just improve the wall around the seating area outside. And at that time, they had mentioned that they wanted to put some permanent bases in with umbrellas that were, they showed me the type of the umbrella, and there would be 3 of them, they'd be 15 by 15 feet. And this is the type of umbrella that was proposed on them. And you can see there's a permanent base that's in the ground. That umbrella sits on it. They can be removed, but they're over 100 and some pounds. So I think what staff felt was that they weren't going to be removed. I mean, you can probably fold them down, but They weren't going to be removed, but the permanent bases would be there. This is the area, I kind of just did a little drawing over it, showing the 15 by 15 square feet for the umbrellas. And this is the existing patio before the construction. And then I just took a newer one today that just shows where the wall is. So what they want to do is put the 3 umbrellas along the front there. The staff recommended denial on this since it does, we were afraid it would violate the setback, the front yard setback. That no structures should be erected above the walls, like 3-foot wall or 4-foot picket fence. The Board of Adjustment did approve it, recommended it for approval.
Thank you. Does anyone at this time have any questions for staff?
Did they need there was no variance required for the wall, right? We didn't see a request for the
No, the wall's 3 foot tall, and that does meet code.
Thank you.
Yeah. But at the time this all came up was when they started to review it.
Anyone else? Eddie, as far as a hurricane or something like that, I mean, or a bad, storm that came up that we didn't really know about, would they stay in the ground? I know they're 100, yes.
That would be a question you ask the applicant.
Okay, okay, thank you. Okay, at this time, I'm going to ask the applicant to come forward and give a presentation.
You just state your name and
State
address
your
for the
name and
record.
address.
My name's Scott Beeble, 1701 Gulf Boulevard, Maine Rocks Beach. And I'm Michael at 1701 Gulf Boulevard as well.
Okay. Kind of tell us about your application.
Yeah, so these umbrellas, they, as Hetty was saying, they're roughly around 90 pounds a piece. And the question you had asked about the hurricane, if we are aware that there's a hurricane coming, these are removable.
Right.
The bases themselves are fastened to a
I don't mean to
foundation.
interrupt you, sir, I'm sorry. If you could just speak a little more into the microphone, it helps in the minutes a lot better. Thank you.
There you go.
Thank you.
So yeah, back to the question you were saying about the hurricanes. If we know there's a hurricane coming and, as we all kind of know, we get a little bit of a heads up, we'll go out there and remove the umbrellas and put them in a more secure, location to where they're not being picked up by the storm. These umbrellas can withstand about 155 mile per hour winds.
That was my question.
Yeah.
Okay.
If I may as well, the whole reasoning we looked into these umbrellas because they can be taken off. And the picture that shows there just shows that it's up. Every night it's going to be folded down into where you can't even tell it's just a folded umbrella. It folds all the way down. They are not going to be left like that every night. They will be enclosed and trapped together just like if you were doing it at your own house. So they'll be able to be strapped together. In the morning when we need them, we put them back up and they cantilever. That's how these things are made. So you can open them and close them as you will. Obviously on stormy days, they won't even be opened up. They'll just be sitting there and they will come out of the base. It's easy enough. It takes a couple people, yes, but obviously we're going to pay attention. We've been around a while. We see what the winds do. The regular umbrellas, they can be removed at any given moment.
Before the commission, do you have any other comments you would like to make about the umbrellas?
No, other than the fact that, we thought hard and long about this process and we want to beautify our business and the community. They're going to look really nice and, frankly, the umbrellas that we have now, they're just outdated. I mean, these things, everybody has these, beer company umbrellas out in front of their restaurants and having we had 8 or 10 of those out there at one time. You get a 20-mile-an-hour wind and it blows and if you've never been in the business, it's frightening because sometimes you just can't get to them quick enough. A quick wind picks those things up. With these umbrellas, they'll barely probably move at all. And then if that's the case, then we can just crank them down, but we're only doing 3 and not worrying about running around with customers on our deck, our servers, all employees for that matter that, possibly can be hurt by a big wind.
Does anyone have any questions for the applicant? Any questions for the applicant? Eddie, do you want to add anything before I go out to public hearing?
Not at this time.
Okay. All right, I'm going to have you go back to your seats and we're going to bring up public comment if there's anyone who'd like to speak. And then we'll have you come back up if there's anything else you'd like to say. Is there anyone at this time who'd like to speak on this agenda item?
While people contemplate that, I'll note for the record, Madam Mayor, there is correspondence in the record which has been provided to you and is part of the record you considered as you previously reviewed the application materials.
Okay. Hearing none, is there anything else that the applicant would like to come forward and say before we go back to the commission to deliberate? There isn't anything? Okay. Hetty, anything else? Okay. I am looking for a motion on this. Yes.
Question I have, I was going to wait till you came back up. Our requirements are there has to be a hardship of some kind. What is the hardship?
Scott, if you want to come forward.
Well, I think the hardship on our behalf is the fact that they are better built umbrellas. And that they don't, you know, they'll withstand higher winds and, you know, they're safer.
Okay.
But I mean, the hardship is you're trying to get rid of the sunshine on your customers.
Well, absolutely, well,
Yeah.
they're umbrellas, yeah, I mean, that's, yeah, I mean, I wouldn't think I'd have to bring that up. I mean, yeah, they're umbrellas, they're actually gonna cover more
Yeah, or.
square footage than the small umbrellas will as well,
Yes,
if that's what you mean by,
the
yeah.
hardship.
Yes.
Yes.
Is there anyone else who'd like to? Okay, hearing none, looking for a motion.
Motion to approve the variance request.
And is there a second?
I'll second the motion.
Deanne, we'll do the roll.
Who seconded it? Denise?
Denise Hosberg.
So I have a comment to
Yes.
make. As part of our deliberation, I was looking at the application and listening to the discussion of hardship, and I do believe that when we think about what Gulf Boulevard was like prior to the eminent domain order, which reduced the property dimensions of our businesses by widening the road, that had the effect of making the property sizes smaller, which sort of puts these walls right at the pedestrian walkway, which abuts the road. So one could reasonably argue that perhaps the land-based hardship comes from the fact that the road was widened and made the property smaller, and therefore the umbrella now is abutting a property line that it would not have abutted in the past.
Okay, thank you. Any other questions before we have Deanne call the roll? Deanne, would you please call the roll?
Vice Mayor McCall?
Yes.
Commissioner Hannah?
No.
Commissioner Hausberg?
Yes.
Commissioner Hoopnagel?
Yes.
Mayor Kennedy?
Yes, motion carries. Thank you. Okay.
We'll now turn to item 6B on the agenda that completes the hearing for item 6A approved by this commission by a 4-to-1 vote. Board of Adjustment case number 2022-02 for 436 20th Avenue. Considering the variance request from section 110-131 sub 1 sub F sub 2 sub Romanet II of the Code of Ordinances to encroach 3 feet into the required 10-foot rear yard setback, resulting in a total rear yard setback of 7 feet, to allow for a 7-foot by 15-foot addition to the existing kitchen for the property located at 436 20th Avenue, Indian Rocks Beach, Florida, and legally described as that portion of Lot 2, 18th edition to re-revised map of Indian Beach. This is also a quasi-judicial hearing. Before we proceed, has any member of this body had any ex parte communications with the applicant or their agent in advance of this agenda item?
No.
All having responded in the negative, has any member of this body done a site visit for the limited purpose of evaluating the application before you this evening?
No.
All having responded in the negative, will city staff or anybody who intends to offer testimony on this item please stand and raise your right hand? Do you swear or affirm the testimony you are going to give this evening is the truth, the whole truth, and nothing but the truth?
I do.
Yes, sir.
Thank you. Hetty?
All right, this is a property located at 436 20th Avenue. And as you can see, it is surrounded by various properties here too. And what they wanted to do here was to add an addition onto the rear of the rear of the house to expand the kitchen. It'd be a 7 by 15-foot addition. At one end, it'd be 7 foot from the property line, and the other end, it would be about 9 feet from the property line. Since you did submit it, we do have letters of approval from all the neighbors, because they do touch on four different neighbors, and all of them, you did get that in your email, that they all approve of the addition to the house. Staff had recommended denial because we figured that there was some other property that you could have added onto the other end of the house. And that it
What do you
wouldn't
mean by
have
that?
created a variance.
Well, just let her get through the presentation, we can ask questions once it's
I'm sorry.
concluded.
Okay, and that's it. So, what were you saying? I'm sorry.
What do you mean by that? The last sentence that you said before that, you said about the property. Say that
Oh.
again.
The property that the staff recommended denial because there are other options to add on to the house.
Okay.
There's other land that you could have added onto on this side, so it wouldn't have required a variance.
And that was my question. What was the reasoning?
You have to ask
Yeah,
that
ask
the
them.
applicant.
Okay,
Yeah.
I'll ask that. Okay, does anyone else have any questions for Hetty at this time? Would the applicant like to come forward? And
Yes.
because we're going to have you, give a presentation to us about your variance, okay? And you can state your name and your address.
Okay, my name is John Kevin Emmons. My address is 436 20th Avenue, Indian Rocks Beach. Just as a little summary about myself and the whole situation, purchased the home in 2016. I'm a proud owner in Indian Rocks Beach. I'm going into my 6th year of ownership there. During that time, I've replaced the roof in 2016, the HVAC unit in 2017. I put new windows on the unit in 2019, upgraded to a 200 amp service in 2021, and put a new front yard fence in 2021 as well. Basically, I submitted all permits and documents, and they were properly submitted for all of those projects. I turned 65 in July, and I will be a full-time resident here in Indian Rocks Beach, hopefully in the beginning of September, but if not, shortly after that, so that's a good thing. The intention was to build onto a kitchen that was already 10 feet by 15 feet, which is not a large kitchen, so that was the intention. The other thing I want to make mention to is I'm not planning to sell this property or flip the property in any way, and I hope to retire a long and happy life there. The other couple of mentions, based on what Hetty had mentioned about the property to the right where you can see some additional land. I mean, based on the diagonal proportion of the backyard and the positioning of the home on the left side of the property, it has created a hardship to be compliant to the setback code. Okay, and then obviously, being compliant to the FEMA 50/50 rule, this has created a hardship and a financial restriction to my building options for this project. And finally, hardship to physically move the kitchen that exists there now to the other side of the house. And, basically with 800 square feet, it would mean I'd basically have to completely renovate the entire house to make my kitchen move to where the bedrooms are now and recreate bedrooms and other sides of the house. Basically, my goal is to make, the home contextually consistent with those in IRB, in Indian Rocks Beach. And, my goal was to enhance my house, and in doing so, enhance the neighborhood as well. So the continual improvement was to renovate the kitchen. So, and as Hetty had mentioned, we're talking about 3 feet on one side and 1 foot on the other side for a very humble 7 by 15 foot expansion into the backyard.
Does anyone have any questions for the applicant?
Just real briefly, so
Yes, sir.
basically, so your kitchen now is kind of in the middle of the home?
No, it's on the left side, which is actually the smaller side of the house. If you look at the diagram, the house is positioned on the left-hand side of the property, so it's already on the short side of the property.
But so you're looking at this just basically due to plumbing and so forth, or access to existing plumbing and so forth? Is that where you're?
Yes, sir. I mean, we'd have to completely tear everything up, and I, based on the FEMA 50/50, I couldn't even do that. The restrictions that the law suggests there.
Thank you.
Welcome.
Any questions? Okay,
May I add something?
you're gonna have an opportunity to
Okay.
come up, but
Thank you.
I'm gonna have you, if there's not any questions at this time, I'm gonna have you go back to your seat, and then we'll let you do a rebuttal after we let the commission and the staff, and then the citizens come up.
Okay,
All right,
thank you.
thank you, sir.
Thank you very much.
Ma'am,
Is
before...
there any,
I'm sorry, go ahead, Mayor.
public comment?
I'm his wife, but I got something.
So, if you wish to speak,
Oh, yeah, you can come up.
you can certainly come up. If you could just stand and raise your right hand, ma'am, I don't believe you were sworn in earlier. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
And just come to my, state your name and address, and you have the floor.
Kimberly Emmons, 436 20th Avenue, Indian Rocks Beach. Another hardship that he forgot to mention is we have we only have one bathroom, and it's a tub and a sink and the toilet. So it's, I don't know, about a 10 by 5 bathroom. So any construction we did on that back bedroom, if we even wanted to flip the kitchen to that side, would affect our only bathroom. So that would add to our hardship. Okay, thank you.
Thank you very much. Okay, I'm going to open the public comment now. Anyone who'd like to come forward and speak at this time, you may come up, ma'am.
Ma'am, I don't believe you were sworn either. Do you...
No, she's coming up during public comment.
I understand she still has to be sworn, Mayor.
Okay.
Do you swear or affirm the testimony you're going to give this evening is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you may come forward.
Hi, my name is Jenny Elliott, and I am a resident here in Indian Rocks Beach, and I'm here representing the owners that live directly behind Kevin, so our backyards touch. And I'm just here to support his request to get his variance. That we have no issue with that, we think it's fine, and we think he should be able to do it.
Thank you for coming up.
Ma'am,
Sure.
can I please have your address?
Oh, my address, the address that I'm representing the owners is 2005 20th Avenue Parkway.
Thank you.
If I may ask, ma'am, what is your relationship to the owners of that property?
Mommy.
Okay, thank you.
Is there anyone else who'd like to come up and speak? Norma?
Do
Easy.
you swear or affirm the testimony you're going to give this evening is the truth, the whole truth, and nothing but the truth?
I do.
Please come forward, ma'am. State your name and address once you're at the microphone, please.
My name is Norma Locamp, and I live at 429 20th Avenue. I also own the property at 435 20th Avenue, both within distance of that house. They have done a beautiful job of maintaining that house, upgrading everything, and now they want to keep it. They want to keep it that way, keep it their own personal home. We support the approval of the variance.
Thank you, Norma. Norma is a very long-standing resident, been here. Norma, how long have you lived in Indian Rocks Beach?
44 years.
Yeah, I know you have. Okay. Thank you for coming up.
Same house.
Same house is right. Is there anyone else who'd like to speak on this variance tonight? Hearing none, we'll close the public hearing. With the applicant, is there anything else that you would like to say before we go back to the staff and then to the commission? Anything else?
Yes, I have my builder here with me, Rick Myrick, who's with the New Room Corporation.
Okay.
And if he would like to say any words, I think I tried to cover
Okay.
the most important aspects of the hardships that we're realizing for this project. But Rick has been a reputable builder here for 30 years.
My name is Rick Myrick, 1727 Coachman, Plaza Drive in Clearwater. So if I can answer your question about it being in the middle of the house is right. The garage is on the left, and then the 2 bedrooms and bathroom are on the right-hand side. So if you were going to do any kind of movement of the kitchen into the buildable area, which is on the right side of the house, you would have a lot more money involved and going to far exceed his 50/50 FEMA value. And so in order to enlarge the kitchen, the only other option would be to come in the inside of the house and move and take out a living space. And so that defeats the purpose of enlarging the kitchen. So there's really no other options for him to try to increase the size of the kitchen. The property line is moving at a quick angle, which you can see. So we're 3 on the one side, 1 on the other as far as encroachment. If you look at his lot compared to the plat of the area, he's got a very small lot compared to the rest of the homes that are there. The depth, I believe, on the one side is like 66 feet, which is much smaller than most of the homes that are down through there. So that's creating a hardship. When they built the home, I don't know what that reason was, but why they shifted the home all the way to the left side of the lot, I don't know. I mean, if they had centered it, he wouldn't even be here right now asking for this coin, for this variance.
Does anyone have any questions for the builder? Okay, thank you. Thank you. I think we're good. We'll go back to Hetty. Anything else that you would like to say? Okay. I'm looking for any comments, deliberation from the commission. A motion?
I make a motion to approve VOA case 2022-02.
And is there a second?
I'll second.
Is there any comments from the maker of the motion?
No, I think well stated what you need to do.
Okay. How about the second?
Just briefly, as the builder notated, the angle of this lot, the positioning of the home, obviously creates some issues along with, the 50% rule. This is like a lot of houses here. Tearing out the whole house to put in a kitchen wouldn't make a lot of sense. That's just my thoughts.
Any other comments from the commission at this time? No. Hearing none, Deanne, would you please call the roll?
Commissioner Hausberg,
Yes.
Commissioner Hoofnagel,
Yeah.
Vice Mayor McCall,
Yes.
Commissioner Hanna,
Yes.
Mayor Kennedy.
Yes, motion carries. Thank you, and look forward to seeing your house. Have a great night.
You're welcome anytime.
Okay. With that, we will go on to 6C, which is VOK case number 2022-05, which is 799 East Gulf Boulevard. Randy, would you read, and does anyone need to be sworn in on this one?
We will in a moment. So this is for Board of Adjustment case number 2022-05 for 799 East Gulf Boulevard. Considering a variance request from section 110-344 sub 3 sub f sub 3 sub Romanet I of the Code of Ordinances to encroach 2 feet into the south 7-foot 6-inch side yard setback and 5 feet into the north 7-foot 6-inch side yard setback, resulting in a south side yard setback of 5 feet 6 inches and a north side yard setback of 2 feet 6 inches, to allow for the installation of a swimming pool for the property located at 799 East Gulf Boulevard, Indian Rocks Beach, Florida, and legally described as a portion of Lot 25, La Hacienda replat, according to plat thereof, recorded in Plat Book 39, pages 1 and 2, public records of Pinellas County, Florida, formerly La Hacienda subdivision, recorded in Plat Book 36, pages 73 and 74. As with the previous two hearings, this is a quasi-judicial hearing. With that, has any member of this body had any ex parte communications with the applicant or their agent in advance of the hearing this evening? No. All having responded in the negative, has any member of this body done a site visit for the limited purpose of evaluating the application before you? No. All having responded in the negative, will staff and anybody here on behalf of the applicant please stand and raise your right hand? Do you swear or affirm the testimony you are going to give this evening is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. With that, Hetty?
Okay, this house is at 799 East Gulf Boulevard. It is it was built as a duplex and then split down the center with a party wall agreement and subdivided the lots back in like 2003. And there was a letter from the previous planning director that's saying, you know, you can't do that, you know, but they did it, and so it's done. So now, now we're looking at, you know, two lots that are 32 feet wide. They are still adjoined with a party wall agreement. And so the one on the south side wants to put in a pool. Originally, we had looked, they had submitted with a 5'6" setback and a 2'6" setback, requiring variances on both sides. And you can see the different setbacks of how this is and what it looks like. And then just recently, after our Board of Adjustment meeting, they did reduce the size of the pool to make it 7 feet on the south side, which is the adjacent lot, you know, single-family lot next door, and then it'd be 3 feet from the lot line with the adjacent building, the duplex building there. We did receive letters of support today, and then letters of that are opposed to it as well. Staff has recommended denial, feeling that they could meet the setbacks on it. And the Board of Adjustment recommended denial on it.
I think Ed has a question for you.
Sorry, Eddie, I just, you had said something that I didn't fully understand. You said the planning director said no, and then it was done, and that was that. Could you elaborate on that?
Yeah, I just saw a letter, just that was sent.
Was there a variance approved to subdivide the lot?
Not on this one.
Is this a legally subdivided lot?
Yeah, they did happen. There's a couple along Beach Trail as well that have done, this happened to. And since then, well, just in the last couple of years, the planning group, you know, for the county got together and said, we need to ask the Pinellas County property appraisers to let us know if people are coming in and subdividing lots, because they could make them non-conforming. You know, like people come in, oh, I bought this lot. It's like, well, good, you can't build on it, you know. And so now they do notify all the communities if somebody is trying to do this. And all I know, the letter was written, and that planning director left shortly after that.
What year was this?
Huh?
What year
How
was
long
that?
ago was this?
2003, 2002, I think. Yeah, I think it was built, let me see where it was built. Yeah, but if this happened, it's happened in a couple other places along the beach as well.
These
And
were all built. These were all built. Yeah. And after they were built, they were subdivided without the city knowing.
right.
That's something
where
I've never heard happen before.
Yeah, well, basically, they're non-conforming lots, they're smaller lots, so,
How do you get a deed on something like that?
what's that?
How do you get
Because
a
the
deed
county,
on
the
something?
county approved these.
Well, I guess so, yes.
You just go in with the, you know, like you, go in and file a piece of paper, you know, on it, and do it as, and then it doesn't require the city sign off like a regular plat would, if you were subdividing, you know, 3 or more lots, I think it is. Has to have, you know, the city sign off or an actual survey. This can be all done in a written document.
Is there anyone else who has any questions for Hetty? I'd like to bring the applicant up. The applicants, if you'd like to come forward, I think you've all been sworn in.
I'm Megan Stein Burton, 799 East Gulf Boulevard. I think it's kind of explanatory. We just want to put a pool in the backyard. Our neighbor Andrew has written a letter of support that he's okay, and he's the one that lives on the left-hand side of our home.
Does anyone have any questions for the applicant at this time?
Do you live on the property?
We do part-time. We live in Wisconsin full-time. And we came to vacation here last year and kind of fell in love with the area, so purchased this home. We're here once about every 5 weeks.
Did you by any chance know that it was non-conforming and all of that when you bought it?
We did not.
Does anyone else have any questions for the applicant?
A technical question, maybe not the applicant. Are you requesting a variance on just the one side now? Because the document we have appears to be requesting a variance on both sides. And then I thought I heard Hetty say that it was subsequently revised, so.
I can speak to this. Hi, I'm Wes Ripley. I live at 2340 126 Drive East in Parrish, Florida. I'm the landscape designer, also friends with the owners. And I'm doing the pool design for them and working with the pool contractor. And I can address any technical questions you have.
Have you changed the dimensions since we have the package here saying it's 2 variances? Are you requesting 1 or 2 variances?
One variance on the one side. We've moved the pool away from the southern side of the property and are asking basically to get closer to the north property, the shared property line.
I'm not clear.
Yeah, it's just, what they're asking now is just for the variance.
The 2-foot setback on the non-conforming left
Well,
side.
actually, it's going to be a 3-foot is what they're proposing now.
On the south side?
On the south side, it's 7 feet.
And on the north side, it'll be 3 feet?
Right.
Not 2 feet, 6 inches?
Yes.
So it's been shrunk a little bit. Yes. Thank you.
Right. In discussions with my pool contractor, basically, if we had 15 feet of setbacks on a 30-foot lot, it'd only be a 15-foot pool, and with the stairs on one side and the depth, the transition would be so steep, it would be kind of awkward transition standing in the pool. So he recommended that we expand the pool to fit in the lot. According to the documents that were drafted up when this property was subdivided, it stated that we would be able to build up to the lot line, and made no mention of this, of the setback.
Anyone else have any questions at this time?
Has that document been, has that document been submitted into the hearings to date?
Did I give you a copy, Hetty?
I might have that, but that wasn't approved by the city. You know, it was an agreement between.
The agreement between the 2 property
Yeah.
owners prior to subdivision?
It must have happened there was another case that there was documents filed, but they're civil documents, they're not something for the city to review.
Understood. I understand.
Yeah, so, and I think they were right at the same time, yeah, that they went in to divide, and then they did those, they're like they're like a condo association.
Common wall, there's a
Yeah, the
common wall
common wall
between 2
agreement.
properties. So it's
Yeah,
shared.
and some say the others have it, like another one said the other half had to sign off on it, if you wanted to do anything to your property. So, and I'm not sure if this one did or not, but.
Any other questions for the applicant? I'm going to have you sit down, we'll go out to public hearing.
Okay.
And we'll open the public comment. Is there anyone who would like to come forward at this time in the public? Hearing none, we'll close the public comment. Is there anything the applicant would like to add? Okay, we'll close the public comment here. Hetty, do you have any extra questions? Does anyone have any other questions for Hetty from the commission? Okay, I'll go to the commission for, is there deliberation or a motion or any questions? Okay.
Well, I guess I have, do you have approval from your neighbor to put a pool in your backyard?
We do.
Okay.
Yes, the letter that was handed to you today.
Okay, so
is
is that
the short one.
the neighbor?
That's the neighbor, yes.
The 801?
Mhm.
Okay.
Motion to deny BOA case 22-05.
Is there a second?
Motion fails for lack of a second, Madam Mayor. At that point, you would need a different motion.
Okay, is there a motion to approve?
Procedurally, at this time, I wish to remind this body that a motion to approve or deny places the matter on the table for vote and for discussion and vote. You are not bound necessarily by your motion for the body to consider and vote on the matter, but ultimately you will have to reach a decision this evening.
Is there anyone who would like to make a motion either to deny or to approve this variance?
I'll make a motion to approve BOA case number 2022-05.
Is there a second?
I'll second.
Okay. With that, is there any discussion from the maker on the motion? No. And from the second, is there any comments from the second?
Oh, we do have agreement. Obviously, there's some things that went on with this property that creates a hardship, unbeknownst to the owner, apparently. We do have agreement from the Commonwealth resident. They did work within the city confines to change it to only the one side variance.
Is there any other comments from this commission?
I just fail to see the hardship that necessitates a swimming pool that encroaches upon setbacks. I believe a pool could be made smaller.
Any other comments? Deanne, would you please call a roll?
Well, I need to,
It needs to be modified because
it needs to be modified because it says to encroach 2 feet into the south. So 2 feet would be,
It would be
I thought it was 3.
3 feet into the north setback.
and then there would be, then the south side would not have
Right.
we would delete that. So it would be a variance request from the section to encroach 3 feet into the north 7-foot 6-inch side setback.
It would be an 8-foot setback, actually.
Hetty, can you just, can we take a,
we need to,
we need to
let's
stop
take a
here.
break and make sure that we have this
Let's-
properly.
Let's recess and make sure we have it clear.
Okay.
While during the recess, you can liaise with the applicant. We will get back on record. You will testify to what the specific relief requested is. The motion maker, if there is so inclined, will amend their motion accordingly, and we will proceed from there. Thank you for sensitizing me to that. I wasn't picking up that issue, but let's take a brief 5-minute recess to work.
Sorry about that.
No, thank you.
All right.
So we are recessed.
What? Yes.
Us back to order here. And Hetty, you can proceed.
Just for the record, we reconvened at 6:35 p.m.
Thank you so much. I'm going to miss that with him.
The request would be for 5 feet into the north side, 8-foot side yard setback, leaving a 3-foot side yard setback on the north side.
Deanne, do you understand that it's 5 foot and then 3 foot?
No, that's not at all what we're saying.
That's not.
No, okay, what it is you've got a total of 15 feet for side yard setbacks, with a minimum of 7 on one side. They have 7 on the one side, so that means the other side has to be 8 foot on the property. So therefore, it's, they're encroaching 5 feet into the 8-foot north side yard setback, leaving 3 feet on the remainder.
A cumulative 10.
Is that?
And for the clarity in the record, when was the proposal amended? Was that amendment made this evening, or was that?
No, it was sent out, it was about a week ago.
Okay.
Yeah.
Has,
trying to make that
Friday.
clear.
as a point of procedure, has that amended variance request gone to the BOA?
No.
It wasn't advertised that way.
Right.
I think as a point of order, this needs to go back to the BOA, in my opinion. I don't believe this is sufficiently documented, just my opinion.
So that is perhaps the first time I've ever heard point of order used properly. So one moment, I have to pull up the city's code so I have the language precisely right. The ordinary procedure is a variance application is submitted to the Board of Adjustment. The Board of Adjustment passes on the application, considers the application, and it is then arrived at, then voted on by this body based on the Board of Adjustment's review. And yes, I am filling the space with words while I look this up. In this case, it is presently my understanding that the Board of Adjustment considered one proposal. After that hearing, the relief sought changed materially. The configuration changed materially, and then this came forward this evening. Is that correct?
That's correct.
Okay. And the powers and duties of the board are to hear and make recommendations on administrative appeals, and recommend special exceptions. Hear and recommend variances from the terms of subpart B as will not be contrary to public interest where, owing to special conditions, a literal enforcement of the provisions will result in unnecessary hardship. And the procedures are, applications for variances are first submitted to the Board of Adjustment and Appeals for recommendation, and then to the City Commission for final decision. That is the opening sentence of section 2-149. Understanding the record before you, I cannot say that it has been, that the variance before this body was first submitted to the Board of Adjustment and then submitted to this body. It was an entirely different configuration. Is that an accurate statement?
That's true.
See, we as a board are not amending this.
Correct.
Right.
Correct.
Someone else amended it. So
Yeah, I agree with you. You're not directing the relief change saying based on, have you presented the same thing and we'd be inclined to something slightly smaller, are you willing to accede to that? The challenge being here that, of course, obviously you folks are here this evening. As you can clearly see, this is not how any of this normally goes. And so it is an unusual procedural posture. However, usually, candidly, people either withdraw their application or dig their heels in the ground and say, this is what I want, this is what I'm going to get. You're trying to work with the process, and the city appreciates that. However, it does have a process it has to adhere to. As we sit here, both in decision limbo and having looked at the code, it is my advice as your city attorney that this matter be tabled until such time as the Board of Adjustment can first consider the same application, the same relief request that this body is considering. And so,
and just to be clear, you're advising us.
Correct. I'm advising you because ultimately
Commissioner.
I have no decision-making authority before this body. I am an advisor and little else.
Question.
Yes.
Does this have to also go back and be advertised as if it was the first time
It wasn't advertised
at all?
that way.
That way.
It was advertised, so yes, it will have to be
So it has,
advertised.
they gotta, okay, just,
They paid for those fees.
right.
Two things can be true. It was advertised. Yes, it was advertised. No, it was not advertised in this particular configuration.
It was, I wrote a second time.
Sir, if somebody on your behalf, please come forward to the microphone. We're kind of running a little fast and loose here. Normally this is them and it's closed, but.
Okay, what we had done after the initial meeting with the original configuration with the variants on both sides, I had a discussion with Hetty, and we agreed that if we eliminate the variance from the one side and only work with the shared side, that we could have a better chance of getting this approved. So we're actually making it.
I understand. You
simplifying-
reduce
we're
the nature of the
simplifying
variance requested,
Right,
and
correct.
the city, nobody is faulting you for that. What we have confronted is what you might consider bureaucratic, but is in a series of administrative boxes checked. In doing that, you may have very well increased your chances of gaining the relief requested. That may be the case, just not tonight, because in doing that, you have changed what you asked for. It's sort of, to use an analogy that is completely imperfect. If you went to your parents as a teenager and said, Mom, can I stay out till midnight? And they said, no, and they said no, and then you went to Dad and said, Dad, can I stay out till midnight? Well, whatever your mom said, or you say to your dad, hey, can I stay out till 11? Whatever your mom said, Mom never passed on the issue at that point. You've now sort of jumped that step. And so the way our code is written, it says it first is submitted to the Board of Adjustment and Appeals, and then to the City Commission for final decision. The relief you have asked for was never considered by that board, and I have to interpret this language, you giving it its plain meaning and meaning to all of its terms. And so we're not faulting you. You're not being denied the relief necessarily. What we're saying is we're here on the wrong procedure. And I understand that that may very well be frustrating, disappointing, and discouraging to you, but we have a procedure to adhere to, and that has not been adhered to here. And that's a lot of here's, I'm sorry. But that's what we're trying to resolve this evening. And so with that, my advice to this body, it is ultimately their decision how they wish to proceed, is that this is not here on the ordinary procedure as dictated by section 2-149 of the code for variances. And so with that, if this body is inclined to proceed, you can consider on the motion pending on the floor presently is to approve relief not requested for, but you can modify that to bring it in alignment with what they've requested. Your other option is to table this issue until such time as the Board of Adjustment has considered the contours of the application you're considering, and I leave that to this body to decide. There is a motion pending on the floor, so if that motion remains pending, now we're testing the Robert's Rules side of this, you'd have to either withdraw, that motion, you couldn't have the, actually, a point of order. A point of order would supersede that motion, so the point of order would have to be resolved first. So we would have to resolve the point of order, which is we're not here on the proper procedure, and that's for this body to decide.
What is the will of the commission? Would you like to table this and have it go back to the BOA, or would you like to proceed?
I would like to proceed.
Phil?
I want to do whatever is procedurally correct.
I don't object to proceeding, but I would like to make very sure that the language is consistent and appropriate. I'm confused at having written requests and being told at the meeting verbally that it's something different, and then trying to orally engineer this new variance. I find it prone to error, and I don't think it's appropriate.
Joe?
Yeah, I would say it is a material change, and it's unfortunate, but we would have to stick with the rules, and it comes back through the process.
For purposes of the record, do we have in the record or otherwise in front of you the advertisement that went out for this proceeding?
It is actually what is written on page 16 of the minutes that's highlighted is what was advertised.
So it was advertised for a relief different than the relief sought this evening?
Yes.
I would suggest to you that is an added procedural defect in terms of putting adjacent property owners and the public at large on notice of the relief sought tonight, where that relief is voluntarily modified by the applicant in advance of the hearing. So that's another issue to consider. Ultimately, we need a decision in this body.
Okay, I think that we have a majority. I apologize to all of you, but because of the legalities, we're going to have to table it. It will have to go before the Board of Adjustments again. I do apologize. I can count on never, in the whole time I've ever been a commissioner and mayor, that we've had to do this. But unfortunately, the legalities, I don't want to see a problem. And I actually think it's probably in your best interest to do it that way. You know, I can't be sure, but I would say I think it's best for you to do this anyway, and the board has made a decision. So with that,
and I want to be explicitly, for the record, Mayor, I just wish to be explicitly clear. This body did not deny any relief requested this evening. It did not grant any relief.
It's been removed without prejudice, which
Absolutely.
means there's no judgment applied to the merits of it. It's just procedurally been delayed.
Precisely. So with that, Mayor, that would conclude the hearing for matter 6C on the agenda.
And the BOA meeting would be March 15th at 6 p.m.
And you can be in touch with the city staff as to the procedure there, and any administrative concerns relative to that. With that, Madam Mayor, we would move down to the agenda. I don't believe there's a 6D, so we'd move to item 7.
is there any other legislative matters to come before this commission? Hearing none. Agenda item number 8, work session items. We do not have any discussions tonight. Is there any other business to come before this board? One thing that I would like to have is, I would like to, at some point, concerning, just went in my head, because I'm so worked up about this. Hardships. I would like to have a workshop on hardships, because for a couple of reasons, not only for the commissioners, I really think the general public and their idea of what hardships is not necessarily what hardships are defined as we interpret them and how we view them. And I think that the commission as a whole, I think we need either, if it's not a workshop on hardships, then I think that a written explanation to the commission is concerning hardships, because I think everyone has a different idea of what a hardship is. And do you have any comment? And I don't want a long discussion on this tonight. I'm just asking you, Randy.
I'm listening, Mayor. My comment is that what you're talking about is functionally a legal term, both within your code and elsewise. Now, some 7 years ago or so, when I first became your city attorney or affirmed it, you did provide a memorandum that explains the variance process at length. That memorandum is still handed out to new Board of Adjustment members. It explains what a hardship is and what is not, what is a hardship that an applicant has created versus one they have not created, or at least what the law has concluded on those issues. I'm happy to recirculate that, and if this body feels that there's a need for continued discussions, I'm very leery of having public sessions discussing legal conclusions that you're in no position to change, unless you're fundamentally going to change your variance criteria and deviate from the norm. But with that, I don't have anything else to add. I work at your pleasure, Madam Mayor.
I think it would be useful to have the memorandum resubmitted and maybe even a summary cheat sheet created so that commissioners could reflect upon that at the time, especially when we're all forced to make a decision in public on TV. So.
Yeah, absolutely. I'm happy to revisit that memorandum, make sure it's contemporary, and recirculate it with an executive summary, and if need be, primer for applicants if this is what the commission is looking at. We can certainly do that, or just make the memorandum part of the application pack materials if that's deemed appropriate. We can look at the course of action.
I would like that.
Okay.
Would that be possible?
I hear your direction, and we'll do so.
With that, is there, I'm looking for an adjournment.
Motion to adjourn?
Is there a second? Second. All in favor?
I motion to adjourn. Thank you.
Thank you. Happy Valentine's Day.